On behalf of Sarathi University School of Legal Studies, today we are pleased to welcome Advocate Srimati Susheela Sarathi, a very special guest from High Court of Karnataka, Bangalore. Advocate Srimati Susheela Sarathi is a designated senior advocate practicing in the High Court of Karnataka in Bangalore. She has done her master's in sociology, a postgraduate diploma in industry relations and personal management, and postgraduate diploma in alternative dispute resolution from the International Center for Alternative Dispute Resolution. She has 34 years of professional practice. Advocate Susheela Sarathi is a trained mediator and master trainer from Bangalore Mediation Center, who has trained many judges and professionals from all other roles in mediation. She has authored many books, including 2 books on mediation in English, Mediation, a Reader's Handbook, and Change Through Mediation, and Madhyasthiki Urdu Karakabidi in Kannada language. Her social psychological novel, Amani Yake Madhuvi Adi, got Kakulu Sarojama Prashasti. She is a renowned columnist. Her columns on legal issues regularly appears in leading Kannada newspaper, Vijayavani. She appears regularly on a small screen in discussion related to social and legal issues. Her blog, True Team Law, gives input to trainer in the field of mediation. ADRS, of course, we have been and having such interesting and insightful seminars so far. Indeed, this is one of a day to have such insightful talk on mediation, which is one of the ADRS process. We're so pleased to have you here, ma'am, and thank you for accepting our invitation.
Thank you.
Respected faculty and friends, now I would like to request you to turn off your video and mute your mic. Please put the question in the chat box, and we'll be having question and answer session after the talk given by Advocate Susheela Sarathi. With that, I ask you to give your full attention to Advocate Susheela Sarathi and help me in welcoming her to the session. Advocate Susheela Sarathi, please.
Thank you. Respected and dear all, it's a matter of great pleasure for me to respect whatever your Dean Sir, Mr. T.R. Subramaniam, asked me to do. It's a great ocean of knowledge. I don't think anybody can say no to him at any point of time. I'm one amongst them. Today, we are going to discuss some aspects about mediation as a process of ADR. Let me tell you how I have structured this, because it's a session of about 60 minutes. And post 60 minutes, now it's 3:15. I think I'll be completing by 4:10. Then we will have 20 minutes or 30 minutes time for our question and answer session. Let me tell you how I have designed this. In mediation particularly, or in any presentation, we try to follow 3 principles. That is called as 3 principles of telling. First, we have to tell what we are going to tell. Number 1. Number 2, tell what you have told that you will be telling. Third, at the end, tell what all you have told. Now, first I will tell you what I am going to tell you in this 45 minutes or 1 hour's time. Then I will definitely try to tell whatever I have promised you. The third part, I don't think I will have time to tell again what all I have told. That I leave it to you so that you can tell it to other friends or other people known to you whom you would like to tell all these things, so that you can tell them what I have told you. That's how I request you to do it. In the first few minutes, I would like to take you through why we need to look at ADR in the present situation, number 1. And what are the advantages our young advocates or prospective advocates have in this field, number 1. Second is, I would like to take you through what exactly is mediation and how the process goes on in actual mediation. And then thereafterwards, I would like to give you some details about the procedural aspects. Thereafterwards, I would like to take you through some of the salient features of mediation. Then some of the techniques and skills. And then some theories related to mediation. One or two theories I will introduce. And then in between some case histories, case study or case histories I would like to share with you. And then at the end, I would also like to take you through some of the advantages that you have, which you may not find in any other alternative mechanisms. That's where I have structured this program. Now, first, why do we need to look at ADR mechanism today is one question. We know that before we even thought of this ADR, even though there was this Arbitration and Conciliation Act, for more than 5 decades it had been there, conciliation was also there, but still probably we have not been making use of it so much. That's one aspect. Second aspect is people have immense faith in the judiciary. In this court system, they have immense faith in court system. Court system is considered as a system of delivery of justice. It's a public system of delivery of justice. Whereas mediation is or conciliation is considered as a process of delivery of justice through private persons. So people always prefer public delivery of justice system. One factor that we need to remember today is that we don't have a statute as on this day as far as mediation is concerned, though there is a strong recommendation by everyone at every stage from every nook and corner that we need to have a statute for mediation. That's one aspect. If we have to wait for a dispute to be resolved through adjudication mechanism only, for various reasons, because of the infrastructure that we have, number of judges we have, looking into the population that we have, considering all these aspects, it is taking a long time. A person who has initiated the process may not reap the benefit of that, whether this way or that way. And we have 3 or 4 tier system. We need to respect that also. Once a litigation ends in one court, the next court's doors are always knocked by the other side. Considering these all aspects, one aspect that we need to consider here is through adjudication we can put an end to litigation but not an end to dispute. Assuming for a while a person has lost before the Supreme Court, law of the land we need to respect, fair enough, but will that person keep quiet? Because the dispute is not resolved, somewhere he is disturbed, what he makes is, he tries to file another case against the other person or tries to instigate somebody else there. So the element of dispute is not resolved, but the litigation may come to an end. What we are looking at through this ADR mechanism is not an end to litigation, but an end to dispute per se itself. That's one of the main aspects that we are looking at. Because ultimately, why are we respected as advocates? Because we are the persons who are contributing in the peacemaking process. But for that, our profession would never have been called as a noble profession. It's only because of our contribution in the peacemaking process, people are respecting us as noble professionals. That's one main aspect that you need to consider. If we are going through alternative dispute resolution mechanisms, what about persons with years of experience? Now there is something that has come into picture nowadays. It's experience vis-a-vis expertise. I am 35-year-old in profession. I have handled hundreds of cases or thousands of cases maybe. But here is a young boy who is not even 2-year-old in profession, but he has got expertise. So what with experience we could not have achieved, I am saying nowadays people with expertise achieving the same or achieving more than what I have achieved also. These are all aspects that we need to consider. And through this ADR maker, now everywhere you go in any profession you step in, they ask you, are you trained in ADR? If you are trained in ADR, wonderful. And there also they will ask, are you trained in mediation? Are you trained in arbitration, conciliation, etc., etc.? If you are a trained mediator, they will ask, are you a trained mediator? Are you trained in family mediation, commercial mediation, IPR mediations? They will ask you all these things. I am requesting you, it has got wonderful opportunity professionally also, and as a human being, you will change definitely. The skills and techniques that you learn in mediation, those skills will help you in achieving your goals in any other profession. Equally so, supposing tomorrow you want to be a litigating lawyer, the skills that you have learned here can be made use of in the best possible way in the court scenario also. But many of the skills that we use in the court scenario may not be useful in the mediation or arbitration and conciliation process environment. This is one thing that I would like to request you to consider. Now let us go to understand what exactly is mediation. Mediation is a process where parties to a dispute get their dispute resolved by themselves with the assistance of a neutral mediator. They get the dispute resolved by themselves with the assistance of a mediator. That means mediation is a voluntary process, it's a confidential process, and it's a process where parties' right of self-determination is respected to a very, very, very great extent. And it's a facilitative process where mediator facilitates the parties to arrive at a settlement. Mediator will not impose his or her views on either of the parties. They will not even give suggestions. Now, understanding what exactly is mediator, what is the role of a mediator? Mediator is a neutral person who facilitates the process, who assists the parties in negotiation, who tries to control the entire process so that an opportunity is provided to both the parties to communicate with each other and, if possible, to connect with each other, to understand each other, to understand the problem in proper perspective, and to find out solutions, n number of solutions, and choose the appropriate solution which would fit in to the circumstances of their own case. This is where a neutral mediator's role lies. He has to be impartial also. There is a requisite that mediator should also have competence. Now, how do we go about this process? How does the mediation process go? The very first process is in greeting and seating. Mediator, virtually speaking, ideally speaking, mediator has to stand up, greet the parties, and then request them to take their honorable seats, which is quite contrary to the courtroom scenario. I'm not disrespecting the courtroom scenario, it's an entirely different mechanism, but here this is what is required to be done. We greet, we respect them, we request them to take their honorable seats. How do you make them sit? If the mediator is sitting in the center, on one side of the mediator, one party sits. Next to that party, his advocate or counsel on record, if anybody is there, he will sit. Thereafter, only third parties, if any, can sit. Likewise, on the other side of the mediator, the other party will sit. Next to the party, the advocate will sit. Next to the advocate, the third parties, if any, they will sit. Nothing in mediation is an empty formality. Everything has a scientific basis. Why do we have parties next to us? Why do we have advocates next to them? we have parties next to them that they feel very comfortable, and we can observe their body language also. We can give a congenial atmosphere for them. These are all the aspects. And why do we request the advocate to sit next to them? If the advocate is sitting next to them, they feel very happy because they have trust in the advocate, which trust they may not have in the mediator on the first day when they enter the mediation center. That's where we request the cooperative role of mediator, advocates also. Many of you may not be willing to be mediators, but you need to, and it's a necessity now, to undergo a course in mediation advocacy, where you should know all the skills of an advocate who can negotiate for the parties or assist in mediation, and you should exhibit your cooperative role. As long as an advocate is sitting next to the mediator, next to the party feels very comfortable. That's one aspect. The second aspect is, between the party and the third parties, if the advocate says the third party is controlling the party, will also be avoided. Many a times party wants to tell something, the father or the mother will pinch her or do something. Don't tell this, do not do this, all these things. Not that we get too much of information by this, but at the same time, the party can speak very comfortably. That's where even where the party should sit also has got a great logic behind it. After this greeting and sitting is done, the mediator makes an opening statement. What is this opening statement? Opening statement is a process where mediator explains how the mediation goes. One of the definitions of mediation is it is a structured and informed process. When we say it is a structured and informed process, we want people to know who are participating in mediation as to how it is structured and informed process. For example, if you go to the courtroom scenario, if a client comes to you, there is a client, there is a written statement, then there is a rejoinder, then there are framing of issues, then plaintiff side evidence, defendant side evidence, then arguments, all these things will be there. But we don't tell the party, this is the plaint, after this written statement will come, this is rejoinder, these are issues, and when the evidence goes, you have to seek leave of the court for rebuttal evidence. All these things we will not explain. The CPC, entire CPC is not explained to the party. And once a decree is passed, how do we go ahead with it under Order 21 rule? These things we will not explain to the parties. But here it is not like that. We will explain them as to how the process goes stepwise. In the opening statement, first statement the mediator makes is, what is mediation? Considering the educational qualification or background of the parties, this he would have known while introducing himself. Once the parties are greeted and made to sit, mediator will introduce himself or herself, and he will also request the parties to introduce themselves. And all the participants there also are required to introduce themselves. Then itself, within 2 minutes of time, the mediator will come to know what is the level of comprehension of these parties. The moment you tell your name, and the moment you tell I am plaintiff or defendant, I am petitioner or respondent, the way in which you tell, mediator can have a very wonderful comprehension as to what is the level of comprehension of the parties who are present there. And the mediator will use a language which is known to both the parties, in which language both are very comfortable. While telling the definition of mediation, a simple definition, mediation is a voluntary process, it is a confidential process, you need not worry about anything. This can also be said. Or you can say mediation is a process where parties to a dispute can get the dispute resolved by themselves with the assistance of a mediator, can also be said. Various types of definitions can be set depending on the level of comprehension of the parties. Then mediator will tell what is her or his role. I am a neutral person. I am not interested in either the subject matter in issue in this case or in either of you. I will be totally, completely impartial. This assurance is given by the mediator. So first is definition of mediation. Second is what is the role of mediator. Then how the process goes, mediator will explain. In mediation, first we have joint session. In the joint session, the party who has approached the court at the first instance, for example, a matter from Supreme Court at the SLP level may also be referred to mediation. But who had filed the suit at the first stage, that plaintiff will be given an opportunity first. He will be requested. Or if it is not court-annexed mediation, if two parties come, between the two, one of them can choose to explain the facts and circumstances of the case. If both of them say, I want to speak first, mediator can take a call. Somebody on the right side can start. Thereafterwards, I will listen to the other side. So a party will be given an opportunity in the joint session to explain the facts of the case. Once the facts of the case are explained by the party, mediator summarizes the facts given by one party, tells the gist of it in a very short form, using skills of paraphrasing and summarizing and reflection. These three skills are used there. Then the mediator will question the counsel or request the counsel whether the counsel would like to speak on the legal issues, if any. By and large, the advocates will say, we will speak about the legal issues later in private session. Once this is done with one party, the same process is done here with the other party also. Mediator requests the other party also, please tell me the facts of the case. I will tell the gist of the case. If I have not understood you properly, you can always correct me. You tell only those factors which you would like to disclose in front of the other side. Don't disclose anything which you would not like to disclose in front of the other side. Only disclosable factors are required to be disclosed. Then the mediator will tell the gist of it. If the party feels that the mediator has not understood her or him properly, they can correct, and thereafter, even this side also, the mediator will request the counsel whether he would like to speak on the legal issues or not. In the joint session, the mediator will also say, in the opening, while telling the opening statement itself, the mediator will say, this is how the joint process goes, joint session goes. But both of you should be aware of the ground rules here. The ground rules are that nothing that goes here can be recorded. It is completely prohibited. Recording is not permitted. Now we are going through ODRs also. We are moving a step forward. From ADR, we are moving to ODR. So online dispute resolution has also come into picture now. So we have to request them and tell them that you cannot record anything, number one. And both of you should respect each other. You should not use unparliamentary words. You should not scold, shout, howl, beat, or assault, but respect each other. When one party is speaking, the other should not interfere or intervene, but wait for your choice. By and large, in joint session, third parties are not allowed to speak. Some cases they may do it, but by and large, in the initial stages of mediation practice, it is better to avoid making third parties speak in joint session. But you can tell them, look, the third parties who are here, other than the disputing parties, can speak to me in private session. After this joint session is over, we will have private session. In the private session, I'll speak to party 1 separately. I'll also speak to party 1 and her advocate or his advocate, sometimes only with the advocate, and different persons who have come with party 1, her mama, her uncle, her dada, whomsoever she has brought, provided the mediator feels that their participation will bring some light to the dispute resolution process. Then we can talk to them. Likewise, on the other side also we'll tell them, both sides I will talk separately. Private caucus, this is called as caucus. It's also known as private session. In private session, mediator spends separately her quality time with the parties so that they can vent out their emotions. Mediator can specially assess them and provide a congenial atmosphere for them to share confidential information, if any. In the opening statement itself, mediator makes a clear statement that if you have any confidential information, you can share it with me in the private session, and the information shared by you will not be shared by me with the other side or with anybody else, and no court can call me as a witness to tell as to what transpired in mediation. If I have made any notes here, I'll tear it off at the end of the day so that you need not have to have any apprehension about this. This assurance is given to the parties. So that the parties can reveal some confidential information. The advantage of getting the confidential information from the party is sometimes with the confidential information, the dispute can be resolved very easily. Not in all cases. Sometimes, notwithstanding there being confidential information, notwithstanding the confidential information being revealed to the mediator, the matter may not end in settlement. But in many cases, it helps a lot. This is one of the aspects. So during this, if it is a court-annexed mediation, as far as Karnataka is concerned, we have 60 days time limit. It can be extended to another 30 days. So in the opening statement itself, mediator tells, look, after the joint session, we have private session with many of you. As we go from one session to another session, lots of solutions will evolve for this problem. If one of the solutions is agreeable to both of you, we will reduce it into writing. Your advocates will help us in bringing it within the framework of law. Thereafterwards, we will take a fair print. Both of you will sign. Your counsels will sign. We will send it to the court. Court will once again check on it as to whether it is in conformity with the law, and then court will pass a decree as both of you have agreed. And the whole process has to complete within 60 days, and we will schedule the sessions based on the time convenient to both the parties. This is how the whole mediation process goes. Assume in the opening statement, what if the agreement is reached is also told to the parties, and what if agreement is not reached also is told to the parties. Assuming for a while matter is not settled here, you need not have to worry. I will only write not settled, or parties could not reach settlement on terms. I will not tell because of whom it is not settled, why it is not settled, etc. So you need not have to worry. The stage from which the court has sent the matter, from the very same stage, the case will proceed in the court. This is how the entire process goes. What are the advantages? At the end, the mediator will also tell them as to what are the advantages of mediation. You can save your time, money, and energy. In court, one of you will succeed and the other may not succeed. The person who has lost may take it to the next level. And for years, there will be a cloud of uncertainty. So now a wonderful opportunity is given to you to write your own judgment, because you have been provided with, you know what are the facts and circumstances, and you know what is best for both of you. And there is yet another advantage. If you have any other case between both of you other than this case, you can also bring it within this umbrella. Even those cases can also be resolved in this mediation process itself. Maybe they are in the same court, maybe they are in some other court, or maybe they have not even been filed before the court, maybe about some cases which are contemplating to file also. All these things can be brought under the same umbrella. This can also be discussed. This is another advantage. And in many cases, there is a provision for refund of court fee to the extent which is different states have made different provisions. So as per that, in so many cases, you will get even the refund of court fee also. And another advantage is that if you settle the matter here, it attains finality and there is no further appeal. All these things are explained, and all these things are explained in the opening statement within a time limit of 5 minutes. between 4 to 6 minutes, a mediator's opening statement is concluded. They will feel very happy. Wow, how nicely this mediator has explained the entire process. Maybe we can get some relief here. They will think. This is a trust building process. As far as mediator is concerned, mediator continuously speaks, uninterruptedly speaks, maybe only in the opening statement continuously, because that's where an impression is created. It becomes an informed process then. And as the actual process goes, they feel, oh, madam had said, now the joint session. The third party will be wondering to speak, wanting to speak. Then he will remember, oh, madam had said. Third parties will also be provided an opportunity to speak in the private session. They will wait. So every stage is informed, and as you have informed, if you take them through the process, what happens is they will feel very happy, and it's a structured and informed process. You are respecting the property. Nobody has got a right to dilute the process in mediation. Take it from me. You have to respect the process. This is one of the important aspects of mediation process. Now you see, after this opening statement is done, party one is asked to speak. He will speak. We will tell the gist of it. The next party will speak. We will tell the gist of it. The counsels, if any, they want to speak, they will speak. Otherwise, the private sessions, n number of private sessions. In between, if need be, sometimes a joint session will also be again held to bring empathetic connections or for various reasons. A skilled mediator can have a combination of joint and private sessions. It's not that only first one is a joint session, last one is a joint session. It can be first one joint session, private, 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 in between joint, private, private, joint, private, like this. There are some cases where parties may not even be willing to look at each other. Then very first session can also be private. Private session with this group of parties, give them a separate opening statement, go to the other room, give them a private opening statement. Even sometimes they have even entered into agreement, but not sitting next to each other or in front of each other, but in different rooms and have agreed because they did not want to see. Fair enough, it is their problem and their solution, and the methodology also can be made flexible depending upon the facts and circumstances of each case. This is one aspect. Now let us try to understand the salient features of this mediation. Mediation is a process where a paradigm shift is brought in the mindset of the parties. When I say paradigm shift is brought in the mindset of the parties, there are 2-3 angles to look at it. We shift the focus from position to interest. Position is what I want. Interest is why I want what I want. I want dongle. This is my position today. Why do you want dongle? Because every speaker has got a dongle. I also want to have a dongle. That may be one of the reasons. It's a prestige issue. Number 2. Number 3, suddenly the current may go off. If the entire whole exercise that we have done may get spoiled. So to be on the safer side, I want dongle. Depending on these 3 reasons, whichever reason is appealable to my son, he will lend his dongle to me. Otherwise, he will say, Amma, I won't give my dongle to you. Isn't it? So what you want is something. Why you want what you want is something. In majority of the partition suits, there will be 35 properties. When we sit in mediation, we ask them, look, this is property number 1. Why do you want share in this? Can you please help me understand? I'm not telling that you should not ask, but can you please help me understand why you want a share in this property, this property, this property? 35 will become 5 or 6. Now the dispute is between what and what? It's only with 5 properties. Instead of, but in the court, they can't do like that. Here what they do, they They bring their focus on what they want only. And they assign some reasons as to why they want what they want. In one case, the lady had filed a suit for partition. She said, I wanted this, that. At the end of the day, she said, I want only the nose stud of my mother. Why? Because as a child, I was always holding her nose thread and then sucking milk from her breast. I still have that fond memory. So if that nose stud is given to me, I don't want share in any of these crores of rupees of property. When this wife was taken to the brothers with her permission, because when you are revealing the confidential information, you should take permission. Can I reveal this to the other side? Yes. Can you tell your brothers yourself? That's wonderful, because always instead of mediator revealing the confidential information, it is better parties themselves are provided an opportunity to reveal the confidential information, because tomorrow the blame cannot come on the mediator. So I brought in them together for a joint session. You said you wanted something. Madam Ji, can you please tell what you want? I want this. Can you explain why you want this? I want this because of these fond memories. That nose stud, which was being worn by the first daughter-in-law of the house, then and there she removed and gave it to the sister-in-law. The matter got resolved in compromise. Look at this. This is how you shift it, you bring a paradigm shift in the mindset of the parties from position to interest. What they want to, why they want what they want. Many a times they will feel, why you want this, why you want this litigation, can you please tell me, why are you continuing? हमारे बाप दादा के जमाने से जा रहा है मैडम ये सूट. हाँ, it's more than 40-year-old suit. Why may I know what makes you to continue this? There is no charm in this at all, madam. Those days they had filed for 2 acres of land. Now I am so rich, I don't want at all. Then, but I don't want to leave this also. Can you arrive at some formula? They arrive at some formula. When you ask why you want something, you will either give up that or you will substantiate as to why you want, so that the reasons that you give is always appealable to the other side. This is one aspect. The second salient feature is we shift the focus of the parties from past to future. We are all prisoners of past. That day it so happened. In matrimonial case, if you ask them, can you please tell me what about some facts that you would like to share with me? They start from the engagement date. Engagement date, they said 200 people will come, but they came only 20 people. To the marriage, they said 300 people will come, but 1000 people came. From engagement, they start. How old is the marriage? Marriage is 18-year-old. From engagement, they start telling you, maybe we will lose all our engagements. We have to sit with this client only, this party only. Nevertheless, what I am telling you here is everybody is a prisoner of the past. We gently tell them, look, we can't have control over your past. We can't change the past. Neither you nor I can change the past. But you can, to a reasonable extent, see how your future can be molded. How you want to see your future. Tell me, you please explain to me, how do you want to see future? This we will not tell them without listening to the past. Because unless emotions are addressed, reasoning will not work out. First, listen to them, listen to them, listen to them. Let all the emotions come out. Then they will be very clean. Then reasoning will start working. Okay, you have explained to me all these things. Past, listen to the past in the present and make them forward, make them look forward to have a picture of the future, which is a possibility. Desires should tally with possibilities. They cannot have some desires which can never be fulfilled by anybody. So once emotions are addressed, reasoning will start functioning. Then slowly the mediator will set the tone. This is what is called as one of the wonderful skills of communication. The two major skills or techniques the mediator uses in mediation is, one is negotiation and another one is communication skills. Setting an atmosphere. She sets an atmosphere and then asks them, how do you want to see the future? What you are looking at, what you are expecting. Is it going to happen? Can it happen? Is it possible for the other side to fulfill this expectation? All these things will be addressed. So the second silent feature is shifting the focus of the parties from past to future. Second one. Third one, from tangible to intangible goals, from intangible goals to tangible goals. I want divorce. I want divorce and 1 crore rupees of alimony. Tangible goal, 1 crore rupees. During the course of mediation, they both understand there is a common interest which is more important for them, that is the interest of the children. So they say, we don't want interest, we will go with each other. The wife who says, I will never give divorce to the husband, she will say, I don't want divorce because this Mangala Sutra, this Tali is very important for me. From tomorrow, I am not wife of so and so. I am losing the status. My husband may give me 1 crore rupees, 2 crore rupees, a bungalow, a car, everything he is offering me in lieu of the divorce that I am agreeing to. But I don't want to agree. I want to be in a thatched house, hut. I would like to be in a hut, but I don't want to have a tag that I am a divorced woman. The status is very important to me. So here there is an intangible goal. But over a period of time, she will understand what is the fun in having a husband in some other country and not having relationship with him, only having a relationship of husband and wife for the namesake on paper, and only this Mangala Sutra is a reflection of the husband. She has never sat with him, never slept with him, never enjoyed anything, any companionship with him. So that will bring a sense to her. Maybe it will bring, in some cases it has happened, and they agree, okay madam, X amount of money we will take and we will go for divorce by mutual consent. So what is it here? Instead of intangible goal, they are going to tangible goals. So these variations will always happen. Now you see, I told you about this mediation as a process. We also consider about negotiation in mediation. In fact, I request each one of you to undergo 40 hours training process. Maybe you will become mediator or not, that's a different issue, but that will definitely take you to a higher level of standard of life, I tell you. That's very, very important. In mediation, there's a separate subject known as negotiation. In fact, in Western countries, if you see the alternative dispute resolution mechanism, negotiation is also one of the alternative dispute resolution mechanisms. Some clients hire the services of negotiators. In fact, how do you help your clients when you come to mediation? You are not a mediator. You are not a party. You are only a counsel. If you are trained in negotiation skills, you can get the best for your client. Mediation advocacy is partnering with the mediator to get the best for your client with the consent of your client to the knowledge of the opposite client. Look at this. Both the lawyers are trying. They are partnering with the mediator with the consent of their respective clients in order to see to it that their clients get the best. What is negotiation? Let us try to understand some simple concepts on negotiation. One of the simplest definitions of negotiation can be this: getting what you want at an acceptable price. What is acceptable price is left to the two individuals. Negotiation involves two persons, isn't it? So what is the best price is what is acceptable is for both the parties. Why an advocate should know this? Because sometimes parties agree, okay, I will take this. you as our advocate may feel that, oh, my client deserves much more. Why is he agreeing for this? Don't worry, it is his property, his dispute, his choice. Negotiation is getting what you want at an acceptable price. For example, morning, this saree I have paid 5,000 rupees. Morning, around 1 p.m. I went and bought this saree. He said 7,000 rupees and has given me at 5,000 rupees. I have taken and come. Tomorrow, Vidya, Rama, Ruma will wear the same saree. I'll ask her how much you have paid. 2,000 rupees. Shocked. When did she buy? At the time while they were closing the shop. Morning, in the noon at 1 p.m., acceptable price for the saree for Susheela and the shop owner is how much? 5,000 rupees. At 9 p.m., while they were closing the door, what was the acceptable price for the shop owner and for this lady? It was 2,000 rupees. Sarees are similar. That's where we say what is acceptable to one may not be acceptable to another in a different scenario. Maybe all are section 125 proceedings for maintenance. A rich lady will also, rich lady in the sense a lady who is supported by her father and mother, parents, a rich family background may also file a petition under section 125 against her husband. But what she wants may not be 3,000 rupees from his 10,000 rupees salary. She may want something else. What she wants, you have to find out. So negotiation is getting what you want at an acceptable price. There are two types of negotiation. One is a competitive negotiation. Another is a principled negotiation. As mediator, we will always see to it that parties are encouraged to go ahead with principled negotiation. Cooperative negotiation. In competitive negotiation, a party is focused on what he should get. In principled negotiation or cooperative negotiation, party is not only focused at what he should get, he is also focused at what the other party also should get. It's not I alone, it is we. Going together. I should win, you should sink is the mentality of competitive negotiators. I should win, you should sink. I should sail, you should sink. I should win, you should lose. These are all competitive strategies. There are some persons who adopt an accommodative style where I lose, you win. Where relationships are more important, what they do is I lose, you win. You give this, you give this, you give this. Yes. For everything he says yes. You'll be surprised. Why is he doing this? For him, relationship is more important than winning. So he will say, I lose, you win. But there are some cases where parties will say, I bend a little, you bend a little. I go back a little, you go back a little. I come a step forward, you come a step forward. Here it is more or less compromise. It is what happens. This is what happens in Lok Adalats. You ask for 5 lakhs, he asks for 3 lakh rupees, in between 4 lakh rupees, settle the matter and walk off. Distributive bargaining. So this is what happens. So from competitive, we try as a mediator, we will understand what is the style of this person, whether he's adopting competitive, he's projecting competitive approach or a cooperative approach. Using the best skills of setting an atmosphere, mediator sets an atmosphere in such a way that the competitive approach slowly surrenders itself to a cooperative approach. And a party will try to understand, look, in order for me to win, it is not necessary that the other person should always lose. What is our general idea? Because of adjudications, we have got an incorrect understanding of the whole process. We think that if A has to win, necessarily B has to lose. So If you ask a person, what is your idea of approaching the court? I want to see to it that the B loses. More than telling that I want to see that I want to win, he will say B should lose, because he identifies his victory in the failure or in the loss of the other person. But in mediation, the philosophy is entirely different. We say that in order for you to win, there is no need that the other person should lose. This is how we set up a strategy there. This is how we work. Now we see, as far as this bargaining is concerned, negotiation and bargaining are very important. The advocates assess the parties in bargaining. Why do people bargain? To make the best profit. Number one, they want to get the best. When it is mediation is assisted negotiation is what we say. When we say it is assisted negotiation, it is not just a deal. It should be a good deal. The challenge to the mediator lies, or challenge to the advocate lies, in seeing to it that had they negotiated between themselves, what they would have got better than that they have got through the advocate's assistance, taking them to mediation, where the mediator's assistance has also added value additions. That is where it is not just a deal, but a good deal when there is a negotiator helping the party. That's another aspect. Now you see why people bargain. One is to make profit. Number two, second is they do not want the other side to make profit. They feel that, oh, this person is taking advantage of disadvantageous position of me in coming to mediation. They don't want their offer to appear in mediation or acceptance to come to mediation be taken as a weak factor as against themselves. That's what they are looking at. There are some barriers to negotiation also. One is a strategic barrier. In strategic barrier, a person is more worried as to what the other person should not get than what he should get. See, when we were all children, on a lighter note, I would like to tell, in those days, this UPS and other things were not there. There was tough competition amongst us, some of our students. So if the light was switched off during April, May, that was the examination period, we used to be very happy because nobody is studying and nobody will get good marks. That was the happiness. Not that I should get more marks, is not that. The other girl or my competitor should not get good marks. In many of the cases, when a proposal comes, the parties will avoid that. Why do they avoid that? Because they feel, madam, I have filed the case, and in mediation, the other person is getting something. Why should that happen? In court only I will get something, he will not get something. Here, in bargaining process, both will get. A strategic barrier is a barrier where a person is more worried about what the other person should not get than what he should get. Then there are some techniques to break this strategic barrier. How we have to do that, all those things will be taught to you in actual mediation training process. 40 hours training, they will give training in all these things. Another aspect is principal and agent barrier. There is some conflict between the principal and agent. For example, 5 brothers are there on one side, 2 brothers are on another side. Between the two, one brother has given power of attorney to the other brother. The power of attorney holder, he does not want to compromise, whereas the person who has given power of attorney wants to compromise. But who is coming for mediation? It is the power of attorney holder who is coming. There is some conflict of interest which the agent has got with the principal, or the principal has got with the agent. That is why the settlement may not happen. This is one of the reasons why settlement may not happen. Another one is cognitive barrier, is what we say. It's a psychological barrier. What is this psychological barrier? In the hopes of getting a larger benefit on a future date, I will not agree to accept something which is reasonably fair or good as on this day. A person has filed a suit for recovery of 10 lakh rupees. Defendant says the document is forged, agreement is forged, the check is forged. He should not give anything. He need not have to give anything, even 1 rupee also. What is the defendant offering here? 0. What is he claiming? Plaintiff 10 lakh rupees. With interest, it has come to 15 lakh rupees. During mediation, the defendant says, I will give 5 lakh rupees. Or I will give only principal without interest. The plaintiff will not agree. Why are you not agreeing? Can you please tell me? Can you help me understand what makes you not to agree this? We ask this in this tone. In body language is very important. There is a separate chapter on body language. So when we ask like this, the party will say, if I win in court, I will get after 10 years, it may take 10 years. Okay, after 10 years, I'll get 35 lakh rupees. Today, what am I getting? 5 lakh rupees. Why should I get? There are chances that you may lose also. Don't mind. I don't mind about that. I don't want to accept 5 lakhs today, but I will take a larger risk of losing entire 35 lakh rupees or 5 lakh rupees or 10 lakh rupees, whatever it is, let it come to 0, but I will take that larger risk. That is where we want the cooperative role of the lawyers. The lawyers will tell them, help them in knowing the strengths and weaknesses of the case. There is something known as different types of mediations are there. Transformative mediation is there, evaluative mediation is there, facilitative mediation is there. Evaluative mediations, much of the Puritans like me, we do not do that. Though I know the strengths and weaknesses, because I'm 35-year-old in profession, I'll have a fair knowledge of what will happen to the result of this case if this case goes till the Supreme Court. But can I tell that to the party? I don't want to tell that. We use the assistance cooperative role of the advocates to help them understand the strengths and weaknesses of each other's case. To make them understand the substantive law and the procedural law. Maybe substantive law is in their favor. Maybe you have a registered will, but you have to prove the will. The procedure has to be followed. How do you do that? It has got so many complications. Can you do that? All those things, we will request the advocate on record to help. That is where the importance of the mediator, the advocate comes into picture in mediation. In reality testing, his role is extremely required. It is very, very essential because only advocate can tell the parties, look, these are the strengths of your case, these are the weaknesses of your case. As I have understood from this, by participating in the mediation, I have understood these are the strengths of the other's case, these are the weaknesses of the other case. Now you take a call. Every stage, the mediator respects the party's right of self-determination. There are two aspects. One is decision-making process and another is decision-taking. Mediator's assistance, if any, is only in decision-making, but not in decision-taking. Mediator can never take a decision on behalf of the parties. Decision-taking is left to the domain of the parties themselves. In the process of decision-making, they need not have to depend upon the mediator alone. They can also take assistance from the relatives, friends, advocates, etc. And then take a final call as to whether they have to agree on something or whether not to agree on something. Different communication skills are used. Different types of questioning skills are used. A mediator is trained in not less than 40 types of different questioning skills. How you have to use, where you have to use. By and large, all questions fall under two categories. One is an open-ended question, another is a closed-ended question. An open-ended question is a question which has got a lengthy answer. In the joint session, first joint session, we will ask them, tell me something that you want to tell me about the facts of your case. That's all. They will go on telling. So much they will tell, open-ended. When did you get married? 1936. How many children you have? 2 children. These are closed-ended question. A closed-ended question is a question which has got 1 or 2 answers. There are several other types of questions which will fall under this category. For example, one is eco-parenting. Eco-parenting is used as a wonderful technique. An auto rickshaw driver's wife files a petition under section 125 CRPC. The auto is not her husband's auto. It's somebody else's auto which he takes every day, uses it, and at the end of the day shares his profit between himself and the owner of the auto. The house he stays is not his own. His grandmother's house, which is given in some slum area by the government Ashriya scheme. There is a disabled sister, there is a widowed mother, there is a blind grandmother, there is a limping brother. All these persons are there. This wife files a petition for maintenance under section 125. What is your expectation? Can you please tell me? If I ask, she will tell 50,000 is enough, madam, per month. 50,000 rupees per month she wants. From whom? From this person. All that the mediator does is, can you please repeat how much did you say? How much did you say? 50? 50? 50, madam. 50 you said? No, I don't want 50, madam. It can be 30. What did I do? It's just eco-parenting. You have filed a petition for a suit for partition for 35 properties. Mr. Raju, you have filed a suit for partition for 35 properties. Please see here, this is 3 cents of land, this is 1 acre of land, this is 1 land in some near some hillock, 40 kilometers away from your homeland. You have filed a suit for partition in all 35. Do you mean to say you want partition in all the 35? Help me understand. I am not telling that you should not ask or you should ask. I have asked, madam, but all the 35, no. 25, okay, madam. What are the 25? Do you want in this? Are you sure you want in this? I am only eco-parenting. When I am eco-parenting, parties will think twice. And then they may agree, they may not agree. That's different. But I am telling you, giving you cues about some of the techniques that we use, which may look very trivial, but they are very vital as far as mediation is concerned. We use a lot of importance for listening. Active listening is a wonderful skill. If you are trained in mediation, it's so helpful for you that you will develop this skill, which is an essential skill for any human being. Even your relationships will improve. Your role as spouses will improve. Your role as children will improve. Your role as parents will improve. So active listening is something where you can get a wonderful training while undergoing this mediation training also. Now it's 4:15. I commenced at 3:50. So I would like to stop at this. And I request each one of you to request Mr. Dean Subramanya sir and see to it that he arranges for 40 hours training program for all of you. All of you undergo that training program so that it will not just be a feather on your crown, but I would say a part of your head will be replaced. We will have something else added to that. That beauty is different. And I'm not telling that just because I'm passionate about mediation. I'm telling you, I'm really envious. I'm really feeling jealous of all of you. Youngsters are given this. We started this at what age? 50 plus. I'm 58-year-old. I am 59 now. We started very late, but for you, this opportunity. Had this been with us about 25 years back, our profession would have been different. Our lives would have been different. I request each one of you to take mediation very seriously as a profession and also as a passion also. Thank you all.
Thank you so much, ma'am, for sharing with us the extraordinary amount of knowledge you held on this topic. Once again, thank you, ma'am. Now we will be proceeding towards the question and answer session. And to moderate the same, we have with us Ms. Chandra Rupa Chatterjee, Faculty, CMR University, School of Legal Studies. Ma'am, I request you to take over.
Thank you so much, Susheela, ma'am. It was very insightful. Students, if you have any questions, please put it in the chat box. This is a golden opportunity. You can ask your doubts regarding the session, regarding mediation in general. Please participate and put your questions in the chat box. Ma'am, there's a question. I would read it out for you. Ma'am, you
Yes.
spoke about the importance of the role of advocates in many mediation proceedings. However, it is not generally in advocate's best interest to end a dispute because he's going to lose his legal fees and etc. How does the mediation ensure that this personal interest is not minimized?
Why does a party come to us? In fact, I told you in the first, well, in my opening statements of this session itself, I said our profession is respected because we bring an end to the dispute. Nowadays, even for mediation, the counsels are being paid very well, and they are telling us that look, as soon as the matter is referred to us, or even when the parties approach us, supposing I am an advocate, they approach me now. Now that I am a designated counsel, senior counsel, they may not approach me directly. But assuming for a while I am an advocate and they approach me directly, then what do I tell them? Look, these are the facts of your case. According to this case, I have to do like this, do like this. I would like to suggest that this matter can be referred to mediation. In mediation, if the matter gets resolved, this is my fee structure. If you fight, this is my fee structure. In fact, personally speaking, I started earning a lot after referring many cases of mine to mediation. In the initial stages, everybody was telling, look, madam has now turned to a mediator advocate. She is not an arguing advocate. Maybe she will send all the cases to mediation. Is it so? They used to ask my junior colleagues also. But over a period of time, they have also understood. Now people want remedy. What is it that you are doing? By referring a matter to mediation, you will never lose a case. In fact, if a matter gets resolved earlier, you will have 10 more cases referred to you. Yes.
Thank you, ma'am. Ma'am, the next question is, how does a mediation decision reach its finality? Is it binding on the parties?
Yes, it is. If it is court annexed mediation, through court annexed mediation, we have to get it final. I mean, once the mediation settlement is arrived at between the parties, the settlement is sent to the court. The court will look into it, and all the components of Order 23. If you go through Order 23, if there is a compromise between the parties in any civil case, then Order 23 will be the ruling factor. Then what they do, court will see what are the factors to be seen. Then if the court is confident that there is no fraud or anything of that kind, and all the parameters are set in, then the courts will pass a decree. So it attains finality and there is no further appeal. If it is not court annexed mediation, then, and because we don't have a statute as of now, there are some situations where you have to get into a private agreement and then that has to be registered. If it's a partition between the parties, partition deed has to be registered. If it is a relinquishment deed has to be entered into. If it's a divorce between the parties, no settlement outside the court can happen. Again, there can be a private mediation, post which they can file a petition under Section 13B of the Hindu Marriage Act, and then they can get the matter resolved. Again, once again, referring it to mediation.
Right, ma'am. The next question is, ma'am, are the parties mandated to have a counsel for the mediation process?
No, not at all. They need not have. In fact, in Bangalore Mediation Center, we have evolved a process where there is a format where they sign. I would like to appear without the assistance of a counsel. We take signature on that, so that tomorrow they should not feel that one party is assisted by the counsel and the other party is not assisted by the counsel. But I have seen many cases taking a wonderful turn where there is a cooperative role of advocates. And my own office, if those who have undergone training in mediation or mediation advocacy, with their assistance, I have seen the mediation settlements being happening very often than with the assistants of advocates who are not trained in mediation. Not that I am belittling them. I have respect for all. But there is an added advantage. There is definitely an added advantage. If you are trained in mediation advocacy or trained in mediation, you can get the best for your clients.
Thank you, ma'am. Ma'am, the next question is, the student wants to know that what are the challenges that people have been facing in online mediation, and is it any different from the physical mediation that had been happening pre this lockdown period?
There is not much of a difference. In fact, I would say this online dispute resolution or physical dispute resolution mechanism, virtual mediation, physical mediation, all those days have gone. Now the stage has come where it is just dispute resolution. Number one. Number two, many a times we feel that we are missing on the non-verbal cues. Maybe some of the non-verbal communications we may not be able to, because when you are telling something, if the way in which you have put your legs, for example, now I am speaking, you are not able to see the whole body of mine, how I am sitting, how my legs are, all these things. But nevertheless, the tone, etc., there are different aspects through which you can get cues. And some aspects that we need to consider now is that we are not completely prepared for online mediations or online dispute resolution mechanisms, because some of them, they do not know how to mute, how to unmute, all those things. But over a period of time, we will know that. We were once going by bullock cart, miles and miles. Today, going by bullock cart is difficult for us. Nobody chooses to go by bullock cart. But earlier, they used to travel so many miles. Over a period of time, they will get adjusted to this.
Right, ma'am. Ma'am, there's another question. Ma'am, which says that in matrimonial matters, what if the mediator gets to listen a completely different set of facts from each of the parties? Then how does the mediator conclude which side is right and which side is wrong?
Mediator does not conclude. For example, in fact, there is a clear prohibition on mediator not to have any opinions at all. We cannot be judgmental. That is what they teach us. In the first preliminary training itself, they will. For us, both are right, both are wrong. No. We don't say who is right, who is wrong, who is not right, who is not wrong. For us, in one case, it was a matrimonial case where the contention of husband was that the marriage is not consummated. Wife did not allow him to have physical relationship. The wife's contention was that they had wonderful sexual relationship for 3 years. Throughout the mediation, they stuck on to their own positions. He says nothing. She says everything. How do you go about it? We don't say one. That's where when the matter was referred, one person said, when we had this for mock mediation, one of the persons said, one of you is telling lie. No, a mediator should not use this. Maybe one of you is telling the truth. See how differently we use the language. But all said and done, we are not here to judge what has happened on that day. What has happened on that day is known only to both of you. It's not known to us. We believe both of you. How do you want to take forward? That's where we use the technique of moving from past to future. We will never conclude who is right or who is wrong. That's not our option at all.
Right, ma'am. Ma'am, one student wants to know that if he wants to follow a career in mediation, where and how do he start from?
Now, MLU, Mumbai Law University is offering 2 years master's degree in mediation. But that was supposed to be a regular course. Because of the COVID situation, suddenly they opened it as a online. They converted it into online process. Maybe other places also they will start. Now, some of the universities are offering, some of the private organizations are giving this 40 hours training in mediation that they can take. They can start using their skills in assisting in mediation through mediation advocacy. They can also start their private mediations where small litigations come. They can get both the parties and try to resolve. And if they want to do some certification courses, if their time and purse permits, Pepperdine University is the best. Harvard University is best. They're all very expensive, but they're all extremely good, extremely good. And so many courses are being offered. Now through online also several courses are being offered. ADR, ODR from UK, that's also good. They're also offering courses in India at a cost of, I don't know, between 30 and 50,000 rupees, maybe a range of 30 and 50,000 rupees. So you can consider all these things. And you can do internship with some senior mediators, and you can join, probably I'm given to understand that from your university you are also attending mediations, actual mediations from Bangalore Mediation Center. You can visit Bangalore Mediation Center, you can visit Delhi Mediation Center, Chennai Mediation Centers, gain knowledge as to how differently each mediator handles different situations.
Right, ma'am. Ma'am, any toughest or the most memorable mediation that you have conducted, wherein you have been able to convert a competitive approach into a cooperative approach, like the most memorable case which you have come across?
I feel that every case is memorable. I don't say that any case is not memorable, but to share you an example, I was really moved when a suit for partition filed by a sister against her brothers. The sister's contention was that she is married to a Christian boy against the wish of her brothers and father, so they are not allowing her to enter the house. So she wanted a share in the property. She was in some other country, and she was gainfully employed. Her husband was also gainfully employed, looked to be very rich. The brothers said, no, we don't want to give because she married a Christian boy, my father died, and we are both bachelors, we want that house, we will not give. However, you tried, this did not work out. Then the brothers revealed that they both tried to convince their father to agree for the marriage of their sister with that Christian boy, but the father had not agreed because they were from traditional background, belonging to a traditional family. This was the scenario. Then what happened was, the brother said one brother is suffering from some illness, terminal illness, the other brother is suffering from some other terminal illness. Maybe within 6 months or 1 year period they will die. After that the sister can take the property. Have you told about your illness to your sister? No, we don't want to tell that. Because if she knows that, she will feel very bad. We don't want to tell that. You please keep this as confidential information. Go to sister, she tells, Madam, I don't have mother. It was my brothers who took the best care of me. They did not marry because if a sister-in-law comes, they may not take care of me. They took so much of care. Even carefree was being brought by my brothers for me. They never allowed me to go to shop. To college also, they used to drop and pick me up. Such was the bonding between us. Now this property is nothing for me. I don't want this property. I want my relationship back. I want my brothers back. But don't tell this to the other side. Look at this. They give the confidential information, but they ask the mediator not to reveal the confidential information. Then the challenge to the mediator is, how do you make them understand the challenge? Make them understand the importance of communicating the confidential information. A joint session was arranged. How was your brother? Oh, he was so handsome. Now your brother is he like as he used to be? No, he looks very weak. Why is he looking so weak? I don't know, madam. You ask him. She asked him. He said about his illness. The other person also said about his illness. And they said they are not going to alienate the property. Both of them hugged together. And then the sister took sabbatical from her job, came back to India, stayed with her brothers until both of them died. And look at this. What we see as a simple suit for partition is it looked as though it's a suit for some tangible goals. Not at all. What she wanted was her brother's love. What the brothers want was also their own sister's welfare. They did not want their pain to be made known to their sister. The intentions are different. That's where we say underlying interests will be made known only in mediation. Why a person has done what he has done will be known only to that person. In mediation, you will come to know that, provided you provide a wonderful opportunity. This was a transformative mediation. It's a sort of eye opener for all of us. There are many such cases where projected prayer is different, actual prayer is different.
Thank you, ma'am. Ma'am, one more, the last question here is, in eco-parroting, if the party is getting uncomfortable just because maybe the mediator is asking the same questions, and what if the party loses confidence in his own claim and he feels uncomfortable, and is there a specific way or some code of conduct which the mediator has to follow?
Yes, yes, yes. Eco-parroting cannot be done. It needs lots of voice modulations. What did you say? Did you say 35,000 rupees? What did you say? I want to be very clear on what you said. This is how we take it. We don't want to make them feel that, oh, you have quoted some exorbitant amount. That's why I'm asking this question. Never, never. They can stick on to 50,000 only. They can stick on to 35,000 rupees only. Supposing you ask me, what is the cost of this sari? I can say 50,000 rupees. If you say 50,000 rupees, still I can say yes, 50,000 also. I don't, mediator should not create any doubt. It is only, that's where there is another technique known as clarification. How you take clarification is whether it's an offer, just an offer, or an informed decision that she has taken, or it's an offer about which she has thought and given that, or it is just a thought that has come to her mind which she is projecting as an offer. In order to get this clarification, mediator is entitled to use the technique, but should be very, very careful. Every technique must be very carefully be used.
Thank you so much, ma'am.
Yes.
Yes, ma'am. It's done. There are no further questions. Thank you.
Thank you.
Thank you, Chandrarupa ma'am, and thank you, Susheela ma'am, for so patiently and so gracefully answering all our questions and clearing all our queries. I would now request Dia, a student of 4th year BBA LLB, to deliver the oath of thanks.
Good afternoon to one and all present here. My name is Dia and I'm from 4th year BBA LLB. I would like to begin by thanking Advocate Srimati Susheela Sarathi for enlightening us on the process of mediation as a form of alternate dispute resolution. In this seminar, we have learned about mediation as a process of alternate dispute resolution and how mediation and conciliation resolve disputes on a more private platform than a public one like litigation. Ma'am has explained the process of mediation, the role of a mediator, the salient features of mediation, and how the process goes. Mediation can be defined as the process by which parties resolve their disputes by themselves with the help of a mediator. It's entirely voluntary and confidential. The role of a mediator is to serve as a facilitator. At no point does the mediator arrive at a conclusion for the parties, but merely helps them arrive at one and offers his opinion on the various options available to them in resolving the dispute. One of the most important skills, as highlighted by Ma'am, of a mediator is negotiation. We have also learned the importance of each and every step of the process of mediation and how it's constituted and their strict adherence to respect one another. This process is so highly confidential that the mediator nor the parties have the right to divulge any information that has been revealed here, except in certain cases where one party requests the permission of another to do so. The ADRS is not meant to end litigation, but rather serve as a means of ending disputes. Thank you so much, ma'am, for this insightful seminar and opening our minds to the concept of mediation and its advantages. I would also like to thank our esteemed Dean, Dr. Subramaniam, our Vice Principal, Mr. Praneshwaram, and our faculty for organizing this seminar. I would also like to thank my fellow students and to one and all present here for helping make this seminar a success. Thank you so much.